Welcome back, everyone, to our weekly webinar. We have a great lineup again this week, very employment law heavy focused agenda this week. And so starting off, we'll have Jacqueline Giordano, who is a member in our Garden City office, talking about what might just be our next protected category, which is caste discrimination. This might be the first place you've heard about this. It's definitely a new topic, and so we'll hear about that. Ksenia Primo's here with everyone's favorite topic, I-9s after that. And she warned me that maybe we all won't like the advice that she has because of some new developments, but it's the reality. Then we have a real treat, Laura Harshbarger from our Syracuse office here, another labor and employment member, talking about some basics that we like to cover in this webinar as well. We like to have a mix of new hot topics as well as the basics to make sure, you know, we're getting really useful information out there. So that will be Laura third. And then finally, we'll finish with a new publication from the Office of Civil Rights about anti-Semitism from Lisa Feldman in our Albany office. So with that agenda, I will go ahead and introduce to you Jacqueline Giordano with her topic. Thank you.
Good afternoon, everyone. Thank you for the introduction, Kristen. So as Kristen mentioned, I'm going to be discussing with you caste, which might be the next category of next protected class in our discrimination laws. So really, this came to the forefront recently. At least it came on our radar recently, back in February, when Seattle became the first city in the U.S. and actually the first jurisdiction in the U.S. to officially add caste as a protected category to its anti-discrimination law. So it's discrimination law against it occurring in the employment context. They defined caste in the law as a system of rigid social stratification characterized by hereditary status, endogamy, and social barriers sanctioned by custom, law, or religion. The law went into more specifics about what endogamy is. It's marriage within a specific group as required by custom or law. And the ordinance also noted that caste discrimination can be based on birth and descent and can also occur in the form of social segregation, physical and psychological abuse, and violence. The law mentioned that caste discrimination often occurs in employment, education, and housing contexts, thus the need for the ordinance to now include that as a protected category. And in fact, several higher education institutions, such as Brandeis University back in 2019, and more recently, Brown University and California State University, have added caste as a protected class in their anti-discrimination policies, even though it's not in the law necessarily in those regions. The ordinance also referenced a recent study which found that 1 in 4 caste-oppressed people faced physical and verbal assaults, 1 in 3 faced education discrimination, and 2 in 3 faced workplace discrimination. Again, the law was just trying to outline the reasons that it was necessary to add caste as a protected category, and in doing so, they referenced that study. Then, more recently, back in May, the state of California passed legislation, at least their state senate did, which would add caste to their list of protected classes. So it passed in the state senate. It's still awaiting a vote in the assembly, and then if that vote is favorable to the law, then it would go before the governor for signature. But it passed by an overwhelming majority of 34-1. However, looking at some of the legislation documents, there were some opposition to the law, including by the Hindu American Foundation, which asked some questions, including absent a historical or current legal basis to regulate caste in the United States, and the lack of an agreed upon legal, academic, or sociological definition of caste, will administrators in the state be asked to rely on India's law related to caste and impose foreign laws on those working or residing in California? So clearly there's a little bit of a disagreement on the definitions of caste. On the previous slide, I had that Seattle had defined it as a system of rigid social stratification characterized by hereditary status, endogamy, and social barriers sanctioned by custom, law, religion. That's a little bit more of a broader definition than California. Their proposed definition, which is on the next slide, says that they define caste, in the law, in the proposed law, as an individual's perceived position in a system of social stratification on the basis of inherited status. Then they go into more detail on what a system of social stratification is. And they say it may be characterized by factors such as inability or restricted ability to alter inherited status, socially enforced restrictions on marriage, private and public segregation and discrimination, and social exclusion on the basis of perceived status. So it talks a little bit, again, about it mirrors in some ways the Seattle's law with the marriage and anatomy reference, but they are slightly different in terms of their definition of caste. I'd also like to point out that there was another argument in opposition to California's bill that was proposed by the, that was a question raised by the Dalit Bahujan Solidarity Network. And in opposition to the bill, they said that most members of their organization in California do not identify themselves as Dalit or reference their caste because they're completely irrelevant in the United States. And it goes on to talk about how this might be problematic and send them backwards in that way. So that's just another interesting point. On the next slide. Okay, so yeah, going back to the California's law, there, as I mentioned before, it has not yet passed in California. And the law specifically says that the act itself is not construed to mean that caste discrimination is not already prohibited under existing law. There's actually a case back in 2022 that the California Department of Fair Employment and Housing, they sued the tech company Cisco, claiming that an Indian Dalit engineer was discriminated against based on his caste. And so the California Department of Fair Employment and Housing said that that kind of discrimination was prohibited under ancestry and race discrimination. So in California, they already have a protected category of ancestry. Obviously here in New York, you know, we have national origin and religion and race, and some of those things might relate back or touch upon caste discrimination. However, in California, they want to clarify and by adding this additional protected category of caste discrimination. So again, it's not yet in effect in California. However, we think that if it does pass in California, which it has a good likelihood of doing so, considering it's a Democratic controlled assembly, that's the next step. And then after that, it would go to the governor, that it might have, you know, repercussions, or it might come down in New York as a potential new category. So to look out for that. And in the meantime, again, just like as in California, it might still come up in the sense of a different kind of discrimination complaint, whether it be based on someone's national origin, religion, or otherwise. But that's all I have for you today.
All right, thanks so much. I appreciate you being here today and introducing us to this really new topic. I mean, I think it's so interesting because from what I've heard about this topic, as you might think, I think it's to the extent this discrimination occurs in the workplace, it would often be between people of the same national origin, right? Or the same religion. And so typically you don't think about discrimination being sort of within a protected category. So I suppose that's how it's somewhat different. And it'll be interesting to see how it develops. I agree with you for sure that once something's passed in California, New York is often not far behind. So trying to stay ahead of the curve here, keep this on your radar. And we will certainly be tracking this as it develops. Okay, moving on to our next topic, which is completely different, is about over in the world of immigration law and the I-9 form. And so we do have a new development here related to the end of COVID flexibility. So Ksenia, go right ahead. Tell us about what's happening.
Thanks, Kristen. Good afternoon, everyone. Thank you for joining us. I'm going to apologize ahead of time for whatever I'm going to say in this presentation. I'm aware that it is going to create a lot of work for some of you, and I apologize ahead of time for that. So before we start talking about DHS ending Form I-9 flexibilities, I want to briefly cover what the process was before DHS implemented certain I-9 flexibilities. Next slide, please. All right, so the regular process, what does it look like, right? So the regular process is this. On no later than the first day of employment, the employee must complete Section 1 of the I-9 form. They are allowed to complete Section 1 of the I-9 form earlier than that. In fact, they can complete it as soon as an offer of employment has been made, but they must complete it no later than the first day of employment. The employer then also has certain responsibilities. Specifically, the employer must complete Section 2 of the I-9 form within 3 days of the employee starting to work for pay, right? So for example, if you hired an employee on Monday and they reported to work and they're working for you, then the I-9 form must be completed no later than Thursday. Next slide, please. And one main point about the I-9 verification process that gets overlooked frequently is that when we complete Section 2, we are required as employers to physically inspect the documents. So, and they must be original documents on top of that. So the normal process, the employee comes to your office with the documents, with the original documents that they're going to be using to complete the I-9 form. You inspect the documents, you make sure that they relate to the employee, you use those documents to complete Section 2 of the form, and then you return the documents to the employee. Next slide, please. So this process was changed by the DHS in response to COVID. We were still allowed to use our regular process, of course, but we were also given certain flexibilities. DHS recognized that in-person inspection was not advisable when we had pandemic, and therefore they put certain measures in place to make sure that we continue to comply with the I-9 regulations, but allowed for some flexibility. So the main flexibility that was allowed during pandemic is the remote inspection of documents, right? What does that mean? Well, the DHS, their position was if the employer was functioning remotely and we didn't have people on site to inspect the I-9 documents, then they would allow for remote inspection of documents. So for anybody who was hired beginning March 2020, that process was allowed. So the employer was allowed to inspect the documents via email, Zoom, copies of the documents, fax documents, and complete Section 2 of the I-9 form by using those copies or other processes. The employer was required to enter in Section 2 of the I-9 form. There is additional information box. So the employer was required to enter in that box that the physical inspection was delayed due to COVID. So that's how the DHS wanted us to handle the I-9 verification process during COVID. And that process is still available. The remote inspection is still available at this point in time. However, next slide, please. The DHS made an announcement that unfortunately the COVID-19 flexibilities will end on July 31st, 2023. What that means is that after that date, we're not going to be able to do remote inspection of the I-9 documents anymore. Furthermore, by August 30th of 2023, we have to conduct physical inspection of all the documents that we inspected remotely during the pandemic. And I realize what burden it creates for the employers. In fact, we all realize that. And honestly, we thought that the government will make the flexibilities permanent because it does cause a huge burden on the employers. We have clients who have hired thousands of employees during that period of time. And now they are required to go back and do in-person inspection of those documents. And sometimes it's just impossible to do that because we don't have HR folks present at all sites. We have a lot of remote employees that are nowhere near our physical locations. So what are we to do here, right? How can we address this particular problem? Next slide, please. So one potential solution is using authorized representative to complete your I-9 form. Who can be an authorized representative? Well, anybody can be an authorized representative. It can be employee's spouse. It can be employee's neighbor. Any person, any adult can be an authorized representative. So how does this process look, right? So basically, if you are doing a remote inspection, you can designate an authorized representative. And by the way, you don't have to make that designation in writing or anything like that. You do not have to have a memo specifically saying that this particular individual is going to function as an authorized representative of the company for purposes of completing the I-9 form. You don't need to have any formal document in place. If you want to, you certainly may, but it is not a legal requirement. So I think the easiest way of handling this process is for HR to get on a Zoom call with the employee and the authorized representative, and then walk the authorized representatives through the I-9 process, right? Explain to them what they're going to be doing, explain to them what documents they're looking at, explain to them how to complete Section 2, and watch carefully how they're completing it, making sure that they're not making mistakes. Because if the authorized representative incompletely completes the form or makes mistakes on the form, we don't get to say we didn't do it. Somebody else made the mistake. It's not our mistake. Whatever mistakes authorized representatives are making, they are our mistakes, and we're going to be liable for them. So what we recommend in these type of situations, if you're going to be using an authorized representative, create a memo to the authorized representative outlining the steps, right? Just kind of familiarizing them with the process and asking them to review the memo beforehand. Then get on a Zoom call with them and walk them through the process and make sure that, you know, they show you the form before it is signed so you can review it and make sure that there are no mistakes. And if there are mistakes, you can at that time correct the mistakes. And that does satisfy the process. I do recommend on the I-9 form making a notation, right, that the form was completed by the authorized representative. So if, let's say, you know, 6 years down the road, you're audited and you're looking at the I-9 form and you don't recognize the name of the person who did the I-9 inspection, you could say, oh, okay, that's right, we used an authorized representative, and then it makes sense. But that's one possible solution to this, you know, a requirement that we must complete I-9 a physical inspection of the I-9 documents by August 31st. Next slide, please. And this slide is just going over what the authorized representative role is. Who can it be? Again, it is convenient that it can be any person. They can be related to the employee. I frequently get questions from the clients. Can we use a family member or a friend? Yes, you can. You do not have to show impartiality or anything like that. It's perfectly fine. Next slide, please. We do think that there is going to be good news down the road, but not yet. The government is seriously considering implementing the remote inspection option as an option for completing Form I-9. They published a notice in the Federal Register regarding this proposal. They've solicited public comments about it, but they're still in the rulemaking process regarding this particular procedure. Hopefully within the next 6 to 18 months, we will have that option available to us. But unfortunately, it is not available yet, and employers need to do their best to be compliant by August 31st. And that's it for this topic.
Okay, thank you so much, Ksenia. There are quite a few questions in the Q&A chat, as I thought we might have. I was able to answer one of them, but I'm not going to be able to answer the topic here. And for this one, we have another member of our Syracuse Labor Department, and that would be Laura Harshbarger. And Laura is going to talk to us today about what you should do or what you should expect when you receive a division complaint, the New York State Division of Human Rights, or EEOC. I know we had a similar topic a few months ago in this webinar, but this is one of those basics that we come across every day here, and so thought it was a good one to revisit with Laura today. So thanks, Laura.
Thanks, Kristen. Yeah, absolutely. As Kristen says, these things come up all the time, of course, right? If you have never received a charge with the New York State Division of Human Rights, or the EEOC, you have a fantastic track record out there. Most businesses at some point in time will experience a charge. And it's good to just kind of review the basics of what that process would look like in the event a charge should come across your desk. Let's start with the New York Human Rights Law and the New York State Division of Human Rights process for looking into one of these complaints. So it's just kind of a reminder of the categories of protected characteristics that the New York State Human Rights Law protects. What happens when a complaint is filed, right, with the based on employment discrimination under one of these categories? Well, a complainant would have the right to file directly in court, and sometimes that happens. Sometimes a plaintiff just bypasses the New York State administrative agency altogether. Not all that often, though, because usually a plaintiff is going to want to capture both state and federal claims, and as we're going to talk about in a minute, there is a requirement for a complainant to file with the EEOC, the federal agency involved, in order to pick up a federal claim. So very often we see administrative agencies being involved on the front end of litigation. If a person is going to file a claim with the State Division of Human Rights and looking for the State Division of Human Rights to conduct an investigation and be involved in some way, normally it is a 1-year statute of limitations to make that complaint to the division, but a 3-year statute of limitations applies to sexual harassment. So one of the first things, frankly, that we're looking at, and you'd be looking at when one of these came across your desk, is when is the last date or the last incident that the complaint complains about? Because there is a possibility, particularly with a 1-year statute of limitations, that in and of itself is going to be a defense to the claim. So there's no fee to file a complaint. Anyone can walk in. You don't have to be represented by an attorney. And of course, this is part of the reason that we see so many of these complaints being filed. One important thing to remember, and I always tell clients this when they receive a complaint from the State Division, or frankly from the EEOC, I'd say the same thing. There has not yet been a determination by the Division of Human Rights or by the EEOC. When that charge shows up on your desk, there's not been a determination yet that it has any merit. Sometimes people are under that impression. Oh, they must think this is really serious because someone went to them and complained, and then they have sent this document to me and they're demanding a response. It's not the way it works. If the complainant complains about something that is covered by the New York State Human Rights Law, or that is covered by the federal statutes, involved, if we're talking about the EEOC, that agency is going to forward us the complaint. There is no kind of substantive judgment call that has been made yet. So at the State Division, when you get a complaint, and by the way, keep in mind, this has been happening more and more frequently lately. The division is using email to send the complaints to the employer. And sometimes they're picking an absolutely generic email mailbox. It could be for payroll questions. It could be for who knows what kinds of questions, customer complaints. And the complaint ends up in that generic mailbox. What then sometimes happens is that complaint doesn't make its way to the right person, HR or corporate compliance or a legal team, to respond to it until time has passed, maybe even until all of the days provided in the complaint have passed to respond. Have no fear. The division is pretty good about understanding that when they send these complaints to a generic email address, they may not make it to the right place. You can get an extension. In fact, even if something dramatic like that hasn't happened, you just need more time to respond. Someone you need to talk asking for an extension of time, because it would be much better to get that extension of time and have a document you're happy with, as opposed to one that was hastily put together and that later we all kind of live to regret. When you respond to this complaint, your response will automatically be sent to the complainant. Again, some employers don't realize that, so keep that in mind. Whatever you send is going to go to the complainant. You don't send it to the complainant. you're just sending it into the Division of Human Rights, but the division will automatically send it on. If there are documents that you would like to rely on in your response that you think are highly sensitive, you can make a request to the investigator to have those kept confidential. And then the complainant will have an opportunity to respond, to submit what's known as a rebuttal. But interestingly, you will not automatically get a copy of that. The employer does not automatically get a copy, and we have to make a special request to obtain that. In most cases, what's going to happen is there will be an investigative conference, which is kind of live interviews. No one's under oath, but it is clearly a consequential part of the process for which you will want your witnesses well prepped and well ready. A record is going to be made of what they say, and you want to avoid a situation where people go into these things thinking it was an no big deal kind of meeting, and then we come out with a record that suggests our folks don't exactly know what was going on in this particular situation, or that we later have to backtrack on from a factual standpoint. I have seen differences upstate to downstate. In my experience, downstate regions of the State Division of Human Rights often do not hold investigative interviews, but it's very much a constant upstate. So what are the outcomes of a complaint to the Division of Human Rights? If the complainant just wants to go to court, that's all they really wanted in the first place. They never really wanted the division's help with this. They didn't want to adjudicate it there. They can get a dismissal, what's called for administrative convenience. It's dismissed out of the division, and then they're just on their merry way to court. Otherwise, you get one of two determinations: no probable cause, that's what we always want as management, and generally speaking, that's going to be the end of the case, at least in terms of the division. As far as the division is concerned, there is a right to appeal. It almost never happens. Once a no probable cause finding is made, you're pretty secure that that's your finding in the case. Probable cause is the finding that means that the division is concerned about the facts of the case, and it will be sent on to a formal hearing in front of an ALJ. At that point, the complainant is in essence assigned a division attorney to represent them if they don't have their own private attorney. The formal rules of evidence apply. People are under oath, and it becomes in essence a mini trial. On the federal side of things, the EOC, there are certain statutes that require someone to file in an administrative agency, whether it's a state agency or the EEOC or another local agency, that the EEOC recognizes as kind of being the same as the EOC for purposes of meeting this requirement. The reason that you have to file is because these statutes require the complainant to have, or the plaintiff to have, what's called a notice of right to sue, which gives the person 90 days to file suit in court. Again, no fee to file such a complaint. Usually you have 30 days to respond. And you can get an extension. What's interesting about the EOC these days is they are using an electronic portal. So again, the complaint is going to come to the employer from the EEOC respondent's electronic portal, and you're going to respond through the portal, which is an electronic upload. The complainant, again, will have access to the position statement if the complainant so requests. So the complainant has a separate portal, and they can elect to see a copy of your position statement, what you have filed in return. It's up to the investigator whether or not to release the exhibits. But one nice feature about the EEOC's process is that you can mark when you upload to the EEOC's website, you can upload certain documents as being confidential. And then as a general matter, those are not going to be released to the complainant. Mediation is almost always offered at the EEOC. It's a very vibrant program. They really are interested in people using the mediation program, and generally speaking, it's the right thing to consider. What are the outcomes? We could have another kind of dismissal for administrative convenience. If all the complainant wanted was to check off a box and go on about their way to court, then that's going to be the outcome. And again, that's just issued whenever the complainant wants one. Or we could get a dismissal with notice of right to sue. And this is something that in the employers that I work with, sometimes they don't understand the difference between state court and the EOC. With state court, or I'm sorry, with the State Division of Human Rights, if the division found no probable cause, they say it. They say there's no probable cause. The EOC's process is a little unsatisfying in that regard, because the EOC's response to not being interested in a complaint is to dismiss with notice of right to sue. They never really say that there was no probable cause here. And that they always give the person the right to sue in federal court. Again, doesn't always happen, happens in a fraction of cases that a complainant would do that, but it does happen. An adverse finding is also possible, and that's called a letter of determination. Here, the EOC is going to say they did find probable cause, and now there's a problem. Now there's a problem, because this can become a situation where the EEOC decides to sue this in its own right. And now it is EEOC, which is the federal government, versus your business. And that's something that clearly we all want to work to avoid. That would be a very serious piece of litigation. Prior to commencing litigation, the EEOC will consider conciliation with an employer that it believes has violated the law. Those conciliation offers are generally not very attractive and quite burdensome. We want to think about strategy in responding to either the division or the EOC, but some considerations with the EOC is that this may just be free discovery in a sense, that the plaintiff's attorney knows they have to file a complaint here, they don't really want to litigate here, and so we do make strategic decisions about how to respond to that. The other thing that we should consider here is you always want to make sure that your response is assuring the EOC that there is not some systemic issue at your place of employment, that you have complied with the law, and to provide good and solid evidence of that. The EEOC only sues about 8% of the cases where it's found probable cause. So, I mean, there's a very, very slight chance really of the EEOC prosecuting a case. But again, I just can't emphasize enough how serious that would be if that were to ever happen. Just honorable mention here, frankly, for the New York City human rights law, for those of us joining downstate, very similar to the State Division of Human Rights, except that we would say this is a very formal process from the outset. The employer has to respond with a verified answer, which is an answer, formal answer that's being sworn to by an appropriate person with the company. And so that would be a tough go alone. A New York City human rights law case. You would want counsel for that, for sure. We would say you would want counsel in all of these cases, but the city human rights law would be a particularly tough road to navigate. So some considerations and strategies here, just to remember that each one of these agencies, it really is kind of a tailored response in addition to the tailoring to the case and the facts of your case. There's a work sharing agreement that we talked about. You should not have to defend in multiple agencies at the same time. It really should just be one, and that one will kind of satisfy all of the other agencies involved. Always recall that there's a document preservation requirement when you're on notice of potential litigation, and certainly a Division of Human Rights charge or an EEOC charge is exactly that. With the State Division, you may find that you have an individual employee or owner or manager named in your complaint, and that's going to raise additional questions about making sure that that person is also represented, whether by corporate counsel or their own attorney. So thanks so much, Kristen. That's the quick overview.
All right, it was really, really helpful. And so we're going to turn over to our final speaker of the day, Lisa Feldman, frequent contributor to the webinar, which we greatly appreciate. Lisa's in our New York office. I said Albany. I think I said Albany earlier. Lisa's down in our New York City office and is going to talk to us about this latest OCR Dear Colleague letter, which I always thought was sort of a funny term that they use to describe their opinions. So go ahead.
Thanks, Kristen. Next slide, please. So as Kristen mentioned, the U.S. Department of Education Office for Civil Rights issued a Dear Colleague letter on anti-Semitism on May 25th. The letter notes the nationwide rise in reports of anti-Semitic harassment, including in schools, and schools within this letter means both K through 12 and higher education. You'll note that this was the same date as the U.S. National Strategy to Counter Anti-Semitism, and this Dear Colleague letter was part of the department's launch of an anti-Semitism awareness campaign, which is referenced in the national strategy. Next slide, please. So the letter reiterates the applicability of Title VI in this context. By way of review, Title VI prohibits discrimination based on race, color, national origin in programs or activities of recipients of federal financial assistance. It extends to students who have experienced discrimination, including harassment based on actual or perceived shared ancestry or ethnic characteristics, or citizenship or residency in a country with a dominant religion or distinct religious identity. Students who are perceived to be Jewish are also protected under this basis, who are or are perceived to be Jewish are protected under this basis. Next slide, please. So the Dear Colleague reiterates the legal standard and cautions that higher education institutions and K-12 schools must take immediate and appropriate action to respond to harassment that creates a hostile environment for these students. And notes that the department may find a hostile environment where there is harassing conduct that is sufficiently severe, pervasive, or persistent so as to interfere with or limit the ability of an individual to participate in or benefit from the services, activities, or privileges provided by a school. Next slide, please. Further, schools must take prompt and effective steps reasonably calculated to end the harassment, eliminate any hostile environment and its effects, and prevent harassment from recurring whenever it knew or should have known of the hostile environment. Specifically, a school violates Title VI when it fails to take adequate steps to address discriminatory harassment, such as anti-Semitic harassment. Next slide, please. The letter also provides examples of when OCR may investigate, such as when students have been subjected to ethnic or ancestral slurs, harassed for how they look, dress, or speak in ways linked to ethnicity or ancestry, such as skin color, religious attire, language spoken, or stereotyped based on perceived shared ancestral or ethnic characteristics. Next slide, please. Some other related documents. The Dear Colleague letter follows OCR's release of a related fact sheet earlier in this year, and we have links to the fact sheet, the Dear Colleague letter, and the national strategy all in here. So when the slides go out tomorrow, you'll be able to access that. And the national strategy described earlier also contains directives for institutions to treat anti-Semitism with the same seriousness as other forms of hate, and to ensure efforts to prevent and address anti-Semitism are integrated into their DEIA programs, including into mandatory trainings on discrimination and harassment. Next slide, please. And so just some things to consider. I'm part of our higher education practice, and so revisiting institutions may want to revisit their anti-discrimination and harassment policies to ensure that Jewish students are included and incorporate anti-Semitism into campus training. And if you have any questions, please feel free to reach out to myself or anyone within our higher education practice that you are in contact with. Thank you.
Thank you so much, Lisa. So that wraps us up for today, a little bit early. One housekeeping item. As you might know, if you attend regularly, I'm here every other week with Gabe on the other weeks. And so 2 weeks from now is July 4th. Can't believe it. So we will not be having our webinar the week of July 4th. We're going to take a break. So I'll be back moderating again 2 weeks after that, and I will see you then. Hope you have a good 4th. Thank you.